Thanks for joining this episode of the number 86 lecture series, where we discuss classical and modern jurisprudence. Today's episode features Lee J. Strang, the John W. Stepler Professor of Law and Values at University of Toledo College of Law. Professor Strang writes and teaches about originalism, constitutional law, property, and religion and the First Amendment. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
The natural law tradition was the original jurisprudence. Can you give us a brief history of the major early thinkers?
The natural law tradition is a long, deep, and rich tradition. It has its origin in Greek thought. It continued through different aspects of antiquity and Roman civilization. St. Augustine played a role, Cicero played a role, Boethius played a role. It had a flowering during the Middle Ages with St. Thomas Aquinas and other thinkers. I think there was also another maybe silver age of scholastic thought, of natural law thought in the 16th century, primarily located in Spain with people like Francisco Suarez. And then for a variety of historical, religious, economic, and sociological reasons, the natural law tradition became more fractured. There became more perspectives, and there's actually debates within the natural law tradition about whether we can say who was in the natural law tradition, who was out of it, and how continuous it was after the 16th century. Some examples of people in the natural law tradition that are often pointed to after the 16th century are Hugo Grotius, Richard Hooker from England. Some people would point to John Locke. Other people would criticize John Locke being put in that position. Alistair MacIntyre, a contemporary American philosopher, has identified the so-called Scottish Enlightenment of a number of people who are Aristotelian and to some degree within the natural law tradition. The classical Thomistic natural law tradition experienced a significant revival in the late 19th century. It was initially in the Catholic world, the Catholic academic world. Pope Leo XIII, in an encyclical in 1890 called Aeterni Patris, identified the writings and thought of Thomas Aquinas as the paradigmatic example of the Catholic Church's approach to knowledge and to metaphysics, and that was implemented throughout the system. And there was really a flowering, sometimes going by the label of neo-scholastics, sometimes going by the label of neo-Thomists, in the early to mid 20th century, with figures like Jacques Maritain, who was a world-renowned figure, was one of the co-authors of the UN Declaration of Human Rights, and so there was a really powerful resurgence of natural law thinking during that time period. I think it's fair to say as well, though, for a variety of historical, religious, and cultural reasons, that the more Thomistic version of the natural law tradition became quiescent somewhere around the mid 20th century. And I think in the Anglo-American world, it really was John Finnis's seminal book, Natural Law and Natural Rights, published in 1980, that revived and made legitimate to a widespread audience a re-engagement with the natural law tradition. And so John Finnis is a modern exponent. Robert George at Princeton is a modern exponent. Germain Grisey, somebody who recently passed away, was a modern exponent. And there are a number of other scholars, both in the United States and other parts of the Anglo-American world, who today are writing about, commenting about, and discussing the natural law tradition.
Let's talk more about modern scholars who work on natural law. Are there new ways of thinking about the topic?
The most prominent modern exponents in the Anglo-American world of the natural law tradition are John Finnis. John Finnis's book, Natural Law and Natural Rights, first published in 1980, was really, I think, a defining moment in the natural law tradition. It brought the tradition in a sophisticated, powerful way to many communities, many academic communities who largely had written off the natural law tradition. Robert P. George at Princeton is somebody in a number of books in defense of natural law, Making Men Moral, and much other scholarship, continued and also elaborated on Professor Finnis's scholarship. Alistair MacIntyre wrote a series of books. Probably the most prominent and most influential was After Virtue, also published, maybe not coincidentally, in the early 1980s. And that gives me an opportunity to talk about another aspect of the natural law tradition, or at least what I view as another aspect of the natural law tradition, which is virtue ethics. So again, natural law tradition is a big tradition. There's lots of debate about what propositions are included in it. My view is that virtue ethics is a component of the natural law tradition, and this fits what Thomas Aquinas wrote. So when you look at Thomas Aquinas' writings, in particular in the Summa Theologica, he has questions dealing with natural law, and he has questions dealing with virtue ethics, or what he would call virtue. He viewed those as two complementary tools, two complementary mechanisms by which human beings are able to identify and then pursue their happiness. So natural law, as we've talked about, are norms, rules, principles, guides to allow human beings to find and to follow and pursue basic human fulfillment. Virtue ethics describes the kind of character one needs to have, the kind of habits, the kind of skills that one needs to have to be able to identify what's good for us, and then to have the ability to best pursue those things that are good for us. And so the virtue ethics tradition talks about the virtues that human beings need to have to live good, happy lives. And that virtue ethics tradition clearly goes back to Aristotle and continues today in the natural law tradition. So what are some of the common virtues that are identified that allow us to live good, happy lives? Justice is the paradigm example. So justice is giving each his due. And there are two different divisions of justice. So one division is on a community-wide basis, where there's a distributive justice, where each member of a community needs to have a minimum level of goods. Now, goods means material goods, but also means other goods, like, let's say, education, to live a decent human life. And then there's, related to that, commutative justice. Commutative justice is the relationship between a small number of individuals. A contract would be a good example, where you have two contracting parties, they both agree to perform a certain way, and commutative justice requires, so long as the contract is basically just, requires both parties to perform their ends of the bargain, to give each other party his or her due. So those are the two kinds of justice, but justice is also a virtue. It's also a disposition that we as humans need to work towards, where our inclination is to make sure that we give others their due. So let's say that we're in a contract and the other party performs his end of the contract. Our goal, our disposition should be, I have a job, I have a duty to also perform my end of the contract, even if it may be a little bit costly for me, or maybe it's something that circumstances have changed and maybe I don't want to do it for some other extraneous reasons. The virtue of justice inclines us to fulfill our end of the deal. Other common virtues are divided up into intellectual and moral virtues. So the intellectual virtues deal with those aspects of our nature pertaining to our reason. So there's theoretical wisdom, which is the ability to know the truth. There's practical wisdom, which is the ability to see and know how to act. There's fortitude, which is courage. There's temperance, which is the ability to use material goods in appropriate manners.
How does virtue ethics apply, in particular to jurisprudence?
Virtue ethics is a part of natural law. Virtue ethics describes the kind of human beings we should be, the kind of character we have, the kind of skills that we should have to be able to identify what's good for us and to pursue what's good for us and to treat our fellow human beings well. And virtue jurisprudence is a manifestation of the virtue ethics tradition. Virtue jurisprudence was, in the American legal world, pioneered by Professor Lawrence Solom. And the idea behind virtue jurisprudence is similar to the idea behind virtue ethics, that in deciding who is a good judge and deciding who is a good person, we need a judge who has the right characteristics. We need a judge with the judicial virtues. So what are the judicial virtues? I think there are four key judicial virtues. The most important judicial virtue is justice as lawfulness. Justice as lawfulness, I think, is the paradigm, the necessary but not sufficient condition for a judge. When we have a judge, we want that judge to judge according to the law. And in fact, a lot of the times when we have discussions about which Supreme Court nominees to appoint or which Supreme Court nominees who should be confirmed by the Senate, one of the questions that always comes up is, to what extent is this judge going to follow the law? Which suggests a widespread consensus that we want judges who are going to follow the law, although we may disagree about what the law is. And so justice of lawfulness is the key defining characteristic of a judge. And you can see in many situations where it would be a virtue that would be sorely tested. So let's say that you're a judge and you have a case before you, and you think the law leads to a conclusion that maybe is inefficient, ineffective, or maybe even unjust. And there are lots of examples of this throughout American history. One of the examples that I point to when I teach constitutional law is Texas versus Johnson. Texas versus Johnson involved Mr. Johnson burning the American flag, being prosecuted by Texas under Texas's flag protection law, and then deciding, was what Johnson did, burning the American flag, protected by the First Amendment free speech clause? And Justice Scalia joined the majority opinion, and then in later conversations outside of court, when people asked Justice Scalia about why he signed on to the majority opinion, one of the things he said was he clearly did not like burning the American flag. Anybody who knew Justice Scalia knew that that was the case. But at the same time, he was committed to what he saw as the legally required outcome in that case, even if he disagreed with that. And I think that's an example of the virtue of justice's lawfulness, following the law, being disposed towards following the law, even if in that particular case you think it leads to a bad result.
How about an example where judges acted the opposite way, when they wanted a certain just result, and so ignored the virtue of lawfulness?
In the context of virtue jurisprudence, one of the additional benefits of virtue jurisprudence is that it gives us additional reasons to be able to praise some judicial conduct and to criticize other judicial conduct. So, for example, the key virtue of judges is going to be justice's lawfulness, the disposition to follow the law where it takes the judge. And there are unfortunately a number of examples in the U.S. reports where the Supreme Court justices did not exercise the virtue of justice's lawfulness. So the virtue in its focal case is the judge should follow the law that governs the case when the judge decides the case. For example, the case of Home Building and Loan versus Blaisdell was a Depression-era case decided by the Supreme Court. Minnesota had a moratorium on the foreclosure of mortgages. And there was a bank that tried to foreclose on a mortgage where the homeowner had not been paying the mortgage payments. And under the mortgage agreement with the bank was trying to foreclose. And the homeowner defended by saying that the Minnesota law prevented the foreclosure. And then the bank responded by saying that the Minnesota law violated the Contracts Clause. The Contracts Clause in the Constitution prohibits states from impairing the obligation of contract. And the Supreme Court justices acknowledged in the opinion that, in fact, the Minnesota moratorium did impair the obligation of contract. And in some ways, it's even more egregious than that, because when the key reason why the Contracts Clause was inserted into the Constitution was because during the period after the Revolution and up to the framing ratification, there were a number of states that passed what at the time was called debtor relief law, which allowed a debtor or debtors to either not pay back or to pay back in inflated means obligations that they owed to creditors. And so the Contracts Clause was meant to stop that, and the Minnesota law was exactly the kind of law that the Contracts Clause was meant to stop. But the Blaisdell court, acknowledging that the law before it in fact impaired the obligation of contract, still went ahead to approve the constitutionality of that law. So that would be an example of justices in that case acting against the virtue of justice's lawfulness, because at the time they decided the case, there was nothing in the text, the structure, the original meaning, or the precedent that authorized the outcome to which the justices came. And so they acted according not to the law governing the case, but according to something else that wasn't the law.
You mentioned that there are 4 judicial virtues, and we've covered the first one, justice as lawfulness. What are the other 3, and how do they look in action?
Another important virtue, maybe the second most important virtue for judges, is theoretical wisdom. When it comes to judges, we would call it legal wisdom. So think of legal wisdom as the intellectual firepower of a judge to master the law. And there are some cases where that's going to be relatively easy. So let's say that you have a simple case under the question, can Congress regulate the commercial transportation of goods on a train across state lines? And under the Commerce Clause, the answer is clearly yes. There's not much work that's involved. But let's say, this is the 1995 case of United States versus Lopez, let's say the question is, can Congress prohibit the possession of a gun in a school zone under the Commerce Clause? Now, under the original meaning of the Commerce Clause, the answer I think is clearly no, because Congress only has the power to regulate commercial transactions across state lines, and possession of a gun in a school zone is not that. But by 1995, as a judge, you have to master not just the Constitution's original meaning, but all of the precedent, both originalist and non-originalist, that is applicable to the case that you're faced with. And I think a great example of this is Justice Rehnquist's majority opinion. Rehnquist's majority opinion described and talked about what the original meaning of the Commerce Clause was. He talks about, for example, first principles of the Commerce Clause. But then he also goes on to talk about both precedent that was originalist and precedent that was arguably non-originalist, cases like Wickard versus Filburn. And then from that, he's able to articulate what he describes as three basic rules or three basic principles in the Supreme Court's constitutional doctrine governing the Commerce Clause, and then comes to a conclusion in that case that's consistent with the original meaning, but also consistent with the other precedent that Justice Rehnquist had identified. And so the point is that Chief Justice Rehnquist by that time had to be able to master not just the original meaning, but all of the approximately 2 centuries of precedent that had come down as well. So justice as lawfulness and legal wisdom are the two most important virtues of judges. Another important virtue of a judge is temperance, or what we might call a judicial temperament. So when we interact with judges, either as citizens or as litigants or judges, especially in their official position, we expect them to operate in a temperate manner. We expect them to rule based on the law's reasons and not based on their emotions, whether they like or dislike personally or for other reasons a party or parties before the judge. Another virtue of judges is fortitude, courage. There are lots of times where a judge is going to be faced with political pressure. There are some times where a judge will be faced even with threats to himself or her family. And so judges have to have the courage to follow the law, even when there might be reason for them to fear what the outcome of that particular case would be. So virtue jurisprudence is applying virtue ethics to judging to tell us what are the characteristics that lead to excellent judging in our legal system. There are some additional implications of virtue jurisprudence. One of the most important is that it helps us understand what are the kind of people, what are the characteristics of people to make good judges. So it's important in our legal system. Judges play an incredible role, both on the federal level and on the state level, that we have judges who have the characteristics that I identified. And so what that does is it tells us we need to create a judicial selection system that's going to identify judges who are faithful to the law, who have the intellectual firepower to identify the law, who are temperate. They're not going to be ruling based on emotions. And so judicial selection is an implication of virtue jurisprudence. Another implication of virtue jurisprudence in the originalist realm is that if it is the case, which most originalists today agree, that there are instances, some say few, some say many, but almost all say, at least in some instances, that the Constitution's original meaning doesn't determine the outcome of a case, then what that means is you have judges who, to some degree, have a choice about how they're going to rule in that particular case. They have a choice about how they're going to construct constitutional doctrine and constitutional meaning that, under the principle of stare decisis, is going to provide guidance to the American political and legal community into the future. And so if you have judges who have that choice, you want to have judges who have the capacity to identify that they have that choice, the inclination to work within the bounds of the law, to not overstep the law, to not find gaps in the law when no gaps exist, and then lastly, to make the best decision for what the law should be in that particular situation. Think of, for example, let's say that you're a judge and you're faced with a decision that involves the original meaning of the Constitution, it involves originalist precedent, and it involves non-originalist precedent. And what you as a judge have to do is you have to master what that body of law is, and then you have to try and apply what that body of law is to the facts before you in that case. And there are going to be some times where those different pieces of legal information, the original meaning, originalist precedent, and non-originalist precedent, are going to point in different directions. They're going to create tensions. And you have to have the capacity as a judge to identify, is there a way to resolve within the law what those tensions are? And if not, to honestly see that there's a place where the law actually isn't giving you a determinate outcome in that case, and then to have the capacity to decide what will be the best outcome, what will be the best law that you as a judge should construct in that case. So virtue jurisprudence plays an important role in modern originalist theory.
Thank you for listening to this episode of the number 86 lecture series on jurisprudence. The spirit of debate of our founding fathers animates all of the number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number86 for lectures and videos on federalism, separation of powers, the judiciary, and more. Thanks for listening. See you in class.